So when we've looked at Vattern as a case, or used Vattern really as a to illustrate why rights of nature legislation is necessary in Sweden, we've worked with one of the senior lawyers who's been representing affected communities around Lake Vattern for a number of years now, and she has really been the chief lawyer in filing against military action and other planned industries such as mining and so on in the Lake Vattern area. Her name is Gunilla Högberg Björk. I don't know if you get in touch with her. So she has used the environmental legislation as it stands, because that's what we have in Sweden, and that's the Swedish environmental code, to show how these activities will damage and damage and destroy Lake Vattern. And evidently those legal injunctions have failed, not so much because of her efforts, but because of environmental legislation as it is today. It simply isn't possible to prove that damage, although it's there and it's taking place, should be prohibited according to the law. I mean, it's I would say that there's again, when we're talking about environmental legislation, we're saying, as it is today, we're saying that you have to prove a certain damage, and in that sense, it's on the affected communities to show that this damage is taking place. Whereas if you have rights of nature, we would be saying, okay, so these are the rights of nature. Lake Vattern has the right to support its living ecosystems and so on, and we have to show that these activities in fact will not harm Lake Vattern.